As I say, 20 minutes presentation. If you want to ask a question, there are two options. I believe you can either type the question in the chat or you can raise your hand and we'll try and get to your question. So perhaps we start off. And do you want to introduce yourself and your history and just a little bit about Compliance Quarter?
Sure. Thank you, Connor. My name is Anne Waddell. I've been a lawyer for over 30 years. I was a barrister for 5 of those years, and I've worked in the courts, National Director of Insolvency at the ATO and various other roles. So now I'm lucky enough to work with Connor in the energy space, which is dealing with a lot of regulators as well. Compliance Quarter deals with compliance issues for companies that are required to deal with regulators. So in the energy space, there's a lot of regulation, as you all know, and that's where Compliance Quarter comes in. We have a compliance hub, and Connor will be showing that later in the presentation, that sets out the requirements. But we thought we would do a webinar on explicit informed consent because it's such an important area for the AER, the regulator, and it also has serious consequences for retailers when they breach.
Thanks, Anne. So yeah, today we'll be looking at the regulations that apply to the jurisdictions that have adopted the National Energy Consumer Framework, and the regulator in that context is the Australian Energy Regulator. A lot of the concepts apply equally in Victoria. There's a separate set of regulations in Victoria, but similar concepts around explicit informed consent. So we start off with some quotes from the previous board member of the AER, Jim Cox, and Paula Conboy. Essentially, explicit informed consent is considered a key protection. It's critical to ensuring that customers are confident in engaging in the energy market. The AER takes failures of retailers to meet this obligation very seriously and will take enforcement action in appropriate cases. We're going to look at some of the previous enforcement actions that the AER have taken later in this webinar. Explicit informed consent is particularly relevant at the moment because we're seeing a greater degree of switching by consumers. And there was an article in the AFR yesterday about this in particular. That switching behaviour is being driven by all of the news coverage and the political coverage of energy costs and increased energy costs. And that's driving consumers to relook at their bills, consider whether they're getting a good deal. And there are plenty that aren't getting as good a deal as they could potentially be getting, and that's driving them to switch. One of the reasons that explicit informed consent is such a focus of the Australian Energy Regulator is that it is relevant for vulnerable consumers in particular. So if you look at the concept of consent, which we're going to look at later on, vulnerable customers, those with limited English, with a disability, or who have some other reason why they're not easily able to understand an offer, are more likely to have difficulty in providing explicit informed consent unless measures are taken to take into account that reason. So we'll look at that shortly. Explicit informed consent is required for a variety of transactions in the energy market. And did you want to talk to us about the elements of explicit informed consent? What's required?
Sure. So as the words would imply, the consent that is given by the customer has to be informed. That is, that whatever it is you're seeking the customer to agree to, the customer has to understand fully what their rights and their obligations are in relation to that relationship that they're about to enter. And as Connor said, that's why it's particularly important if you have a customer that has a poor understanding of English or literacy problems. There are other ways, such as translators and things like that, for the message to be delivered to them, but you have to turn your mind to the fact that you will have customers that have particular needs that impact the way that you deliver the information that you need to deliver. It can't be a one size fits all. So they fully understand the energy offer that is being put to them in terms of any tariffs, rebates, costs, usage, all those sorts of things, that they're under no duress or hardship in relation to consenting. They're not being forced into agreeing by intimidatory tactics, which sometimes, as we've seen, can apply in door-to-door, and they're areas where companies have been pulled up in terms of the tactics that have been applied. It's got to be voluntary, and they have to understand what they're doing. So they have to be free from pressure, undue influence, or duress. So it can't be a situation where they're being told you have to sign on now or the offer will be gone, which is not to say you can't have offers that go for a certain amount of time, but there can't be that sort of pressure imposed. Finally, they have to have the capacity to consent. They have to be of an age to enter into a legal relationship. They have to have been advised of their rights in a way which is suitable. If for a hearing impaired person, it wouldn't necessarily do to talk to them unless they have the ability to hear that, or a visually impaired person receiving something in writing that isn't in Braille. You also need to be very conscious when dealing with elderly people of whether they have the capacity. Now, that's a really difficult area. And Connor, I don't know if there have been many instances in this, but you do have elderly people that have dementia, Alzheimer issues, notoriously difficult to determine that, but you have to be conscious of that too.
Yeah, that's right. And we're going to look shortly at some of the risk factors from a retailer's point of view. Certainly with respect to elderly customers, a lot of the complaints that have come through and go through to the ombudsman schemes, for example, have previously related to particular facilities. So you might have a door-to-door sales agent. That door-to-door sales agent is looking to sign up customers and has an incentive to try and sign up customers. And unfortunately, they're not incentivized to ensure that a customer understands the offer. They might go to a nursing home, for example, and they might do that for two reasons. Firstly, the residents are likely to be home. And secondly, it's easier for them to potentially mislead those consumers, and you might have individuals within a nursing home that have some sort of mental impairment or something along the lines of dementia, and that's a particularly risky area from a retailer's point of view. You're talking about a vulnerable set of consumers. And what we've seen in response to some of the compliance breaches that we'll speak about shortly is most retailers have simply stopped doing door-to-door sales, and that's purely on the basis of the risk of misleading consumers, the problem with the alignment of the incentive for the sales agent, and the potential penalties that the retailer can face should they sign up a customer without explicit informed consent. So there have been some quite significant compliance failures in the past, and many of you may have heard about them online on the news. In 2015, the Federal Court ordered Energy Australia to pay penalties of $500,000 for failing to obtain explicit informed consent. The ACCC also brought proceedings against Energy Australia for breaches of the misleading and deceptive conduct provisions, and there were fines imposed there. In 2017, Simply Energy paid penalties of $60,000 for failing to obtain explicit informed consent, and that was subsequent to fines of $80,000 in 2015 in relation to similar breaches. Anne, did you want to talk briefly about some of the facts in those matters? The Energy Australia case, there were two proceedings, firstly related to a failure to obtain explicit informed consent, and also secondary proceedings relating to misleading deceptive conduct. And I think you're back online now, is that right?
Yes, sorry, I had myself on mute.
That's
So
okay.
I'm talking to myself.
Did you want to talk just about those proceedings? Yeah,
Yeah.
No worries.
The one of the important things to note about this particular case was that Energy Australia were using a third-party vendor to provide customer support services, and that provider was called Bright Choice, and they were actually the party that was engaged in the conversations with the customers. So it is important to remember that at the end of the day, it is the retailer that has the obligation, regardless of whether they have contracted with a third party, in relation to having those conversations. Basically, in the Energy Australia case, the telephone operators were contacting people, talking to them about a partnership with Energy Australia, and advising the consumers that they weren't being signed up to an agreement as part of that conversation, and that they would be sent information that they could look at in their own time, and they wouldn't sign them up without further communication. Now, if that had been the basis of the conversation, that would have been okay, because that's the sort of thing you have to talk to the customer about with explicit informed consent. However, what was wrong with this was that despite all those assurances, the customers were being signed up to a contract. And so after they had agreed, Energy Australia then sent them out a welcome pack on the basis that they had agreed to become customers. And when they were looking at the penalties and the circumstances, it was relevant that Energy Australia had turned its mind to explicit informed consent and had processes and in relation to Bright Choice doing that, but it fell over when they actually came to do it. And this, the other thing is that the ACCC will always publish media releases about infringements and penalties, because that is why they're there, and that justifies their existence, their penalties. So there was quite a bit of attention paid to this particular breach.
Yeah, and in determining the sentence, the federal court, so I'll talk about this slide in a second, but just on that Energy Australia matter, the sort of factors that the federal court would consider include the size of the company, the deliberateness of the contravention and the period over which it extends, whether the contravention arises out of the conduct of senior management or at some lower level. So they're looking at, how high up the tree the conduct related to, or whether the senior executives are aware of the conduct, and they'll also look at whether whether there was a corporate culture conducive to culture of compliance. So a lot of our work is about trying to help our clients ensure that they do have a compliance culture and that they've got some tools in place to demonstrate that. And the court would look at evidence such as education programs, which might include attending webinars, but also face-to-face training programs, and whether when a company identifies that there are potential breaches, whether they've taken corrective action, disciplinary action against individuals, and whether they've acknowledged the contravention. Then the final three, whether the contravener has shown a disposition to cooperate with the authorities, whether there has been similar conduct in the past, the financial position of the company, and whether the conduct was systemic, deliberate, or covert. So you can distinguish between one door-to-door salesperson going around despite a culture of compliance, a compliance program, and doing some things that weren't in accordance with the company's culture, as opposed to an energy retailer that doesn't have a sufficient process in place to try and stop these types of breaches from occurring.
And another thing, Connor, that they'll also look at is in relation to whether a particular demographic or group has been targeted. In the telco space, there have been quite a few proceedings taken and penalties paid by companies, for example, targeting Indigenous people in the Northern Territory and signing them up to telco deals, which were ridiculous because they didn't even have a signal for that carrier when they signed the deal. So, whether a particular demographic has been targeted.
Yes.
The other thing is, in the Energy Australia case, that one of the orders that the court made, and if anybody would like a copy of the judgment, we're happy to send it to you, was that Bright Choice, who was the third-party vendor, would introduce a compliance and education training program, and the program they were required to introduce is an annexure to the judgment. So that's another. There are many and varied orders the court can make apart from just imposing a penalty.
Yeah. So this next slide, which I skipped to a bit too soon, but just to show you a bit of an overview of the actions that the AER took in the previous financial year. So explicit informed consent is obviously a key area. They issued those 3 infringement notices, which we've spoken about. They also, obviously focused on life support. Interestingly, we get a lot of people talk to us about embedded networks, and some of the commentary is, well, what is the AER doing in the regulation of embedded networks? Well, in fact, they reviewed 425 exempt sellers' practices during the year. They issued 5 infringement notices, as many of you will know, to Stockland Trusts, which resulted in penalties of $100,000. And I think if you compare this infographic, which is taken from the reference on your screen, to the one for the year that we're in the middle of, it'll be interesting to see the shift towards embedded networks, I would say, and a continued focus on explicit informed consent, probably customer hardship, which is another area that we're going to look at in a webinar to follow, and of course, life support obligations. In the context of embedded networks, we are going to touch on that briefly because we think that that's an important area. So we've identified some risk factors from the perspective of an energy retailer. As Anne mentioned, vulnerable customers, targeting vulnerable customers is a big problem. It damages the reputation of the whole energy industry. Particular sales methods have a lot higher degree of risk, and that is door-to-door and telesales. Failing to provide required information and information in plain English. So it's not sufficient for a customer to be given a contract that they don't understand. They need to be able to understand what they're signing up to in order to provide explicit informed consent. The whole concept of sales being achieved at any cost rather than all costs, and that has to do with a misalignment of incentives. So you might have a contractor who is motivated just to sell. The potential risk of that is obviously that they're going to go off and sign up a whole bunch of customers without consent. As Anne mentioned, contractors, so this isn't an obligation that can be contracted to a third party. The retailer itself has the primary obligation, and that was the case with the Energy Australia matter. A general failure of oversight. So we get questions about, well, can we just demonstrate explicit informed consent by an online tick box? And the answer to that is, that the retail law says that consent can be provided electronically, but then how would you know whether that individual had the capacity to provide consent, or whether they had a sufficient degree of English proficiency, whether they had a disability. And that's why most retailers, and a much better practice is, sure, you can have a paper contract or you can have an electronic contract, but the customer really needs to be called and the call recorded with their consent. And there needs to be a discussion, an opportunity for a customer to be able to ask questions, to opt out of the deal, and an opportunity made for the retailer to make an assessment to ensure that the customer is able to provide consent. And then the last thing is, as a general observation, this is all sort of to do with the culture of compliance, and the culture of compliance is taken into account when there is a breach, and hopefully a culture of compliance and some compliance tools in place would reduce the likelihood that there is a breach as well.
Yep. And so, Connor, that might be an opportune time for you to show people our compliance hub, which sets out the various sections that are relevant and what it is that's required.
Yeah, sure. So I've just taken the screen share off. I'll just make sure that I can actually log in to our compliance hub. I will just briefly show everybody our compliance hub, which is software that we've developed for electricity retailers and for sales agents and the like. And I'm just going to show, so we've developed a registry of obligations, and that's taken from the National Energy Retail Rules. This is our compliance hub. We publish updates, including about our webinars, about explicit informed consent, and doesn't approve of my picture choice for that one. And, registry of obligations, and the concept is that you type in a word and that you're able to see all of the obligations that relate to that particular area. So explicit informed consent, you're actually able to see the regulations that apply. You're able to see an assessment of the likelihood of a breach, and this is just a dummy report, and the controls that are in place. You can have an owner of that risk. And then we've also got a range of controls in place. So one of those is online training, and we've got some online training that with records kept of who's completed that training, and all of that is designed to reduce the risk of some of these breaches, and also to have a record of activities being completed to reduce that risk. And so we've got...
Well, Connor, I just, one thing in relation to explicit informed consent that's important is that it arises in different situations. So you need explicit informed consent entering into a retail contract.
Yes.
If you're in a brownfield situation, if you're converting it to a embedded network, you need to have explicit informed consent of the residents or tenants. There's a couple other situations, isn't there, Connor, that you were going to talk about?
Yeah, that's right. Yeah, so we can, there's a range of different transactions where explicit informed consent would be required, including, entering into a direct debit arrangement, for example. So not only transferring a customer, but other situations like that. And just on the embedded network issue, something that we've seen, this kind of misunderstanding that a whole building can be transferred over to an authorized retailer or an exempt operator. The obligations are to obtain explicit informed consent of each of the individuals within that embedded network. And I'd suggest that in itself will probably be an area that the AR are going to be looking at over the coming months. It ties into, if you look at embedded networks, you might have vulnerable consumers within an embedded network. There's also the wider questions of customer choice, and the concern of the AR is to make sure that those customers are supplied by a retailer that the customer actually wants to be supplied by.
Yeah.
All right. Yeah. So that's the end of our webinar. Thanks for attending, everyone. If you've got any questions, you can type them up now or send through an email to Anne or myself, and we'll get back to everyone with answers. As I mentioned, we've got other webinars coming up, including on customer hardship. We're going to look at off-grid supply arrangements. We're going to be looking at energy storage and some of the regulatory issues around that. And we'll send through an email with invitations to all of those webinars. But thanks for attending today.
Thank you.